everybody. I'm Charles Longevin with Georgia Parent Human Rights, and we are joined today by attorney Woodrow Ware. Woodrow is a family law attorney, and I guess I'll let you introduce yourself a little bit more than that, Woodrow.
All right. Well, thank you, Charles. I'm excited to be here. Thank you so much for having me speak with you for a little while tonight. I am an attorney. I've been a member of the Bar of Georgia since 2006. Just a little brief summary of what I've done in my career. The first 3 years I worked for Chief Judge John Ott in the Alcovey Circuit. And after that, formed my own firm with my partner, Melissa Shanahan. And we had a firm for about 2 years, and then we amicably split. And since then, I've kind of been on my own. It's just me and my assistant. But during that time, I have represented parents in superior court in divorce cases, legitimation cases, various kinds of custody cases, child support cases. Also did quite a bit of work in juvenile court representing parents against defects, parents whose rights were being terminated and whose children were being taken from them for various reasons. So I've kind of seen it from that angle. Since 2013, I have been a Special Assistant Attorney General for child support for the Division of Child Support Services. So I have been involved in literally thousands of child support cases and have kind of interfaced with parents on that level as well. So I've seen this from just about every single conceivable angle, from the judge's perspective, from the perspective of representing parents in both courts, and also from the perspective of the state in enforcing child support orders and all of the issues that kind of go along with that. So happy to help however I can.
All right. Well, great. And I appreciate you joining us today. I recognize your time is valuable. Now, you have been a huge supporter of ours and of equal shared parenting for quite some time. What I kind of go over what got you interested in equal shared parenting and what it would mean a bill, what it would mean for you as an attorney fighting in family courts.
Right. Well, let me first start it, with kind of how it started for me. When I was in private practice, as I mentioned earlier, I happened to be appearing in front of the judge that I worked for, Judge Ott, Chief Judge Ott. And I was going against an old classmate of mine from Georgia Law, John Mills, who has a firm over in actually a few doors down from me. His office is in Watkinsville. And I was representing the father, he was representing the mother. We were about to have a custody battle, and we were kind of going over Judge Ott what we expected the evidence would show and so forth. And he just kind of stopped us all and said, you guys are about to tear each other apart in here. And I just don't understand why it is that, two very smart attorneys in front of me have not figured out a better way to resolve these kinds of issues than to just come in here and let your clients tear each other apart. And I remember kind of looking over at John and him looking at me, and we were kind of like, what is he talking about? Where's this coming from? Of course we're going to tear each other apart. That's what we're supposed to do. It's an adversarial system.
Right.
And then, of course, right after that, we had the hearing and we tore each other apart. And then the parties ended up settling the case. But that experience always kind of stuck with me. And I remember from that point forward, I don't know if I Googled better way to resolve, parenting disputes and somehow found my way, into the shared parenting world. And it was just like an awakening. It was like an epiphany. My goodness, this has always been here. It's like the answer that's always kind of been there. And then I started looking into the science of it. And I mean, the more I studied it, the more I researched it, the more I realized that I was just kind of a part of a system that was just heading in the wrong direction, in the worst way. And in the process of that, hurting a lot of people financially, of course, getting them to spend a lot of money that they really didn't need to spend, that was better spent, in my opinion, on, education for the children. I mean, that's what I think about over and over again whenever I see, tens of thousands of dollars being spent in these custody disputes that courts just are not very well suited to resolve. You come up with an answer at the end of it, but there's really no indication that it's a good answer. But at any rate, and the children, one thing I didn't mention earlier is that I also did quite a bit of guardian ad litem work. So I represented children in these disputes as well, in addition to representing the parents. And, speaking with the children, seeing the toll that it was taking on them, just being part of this process and watching their parents. And you just get the overwhelming feeling that these parents don't really realize. I mean, I don't question that they love their children. They don't realize how damaging what they're doing is to them. And when you practice from whatever angle you're coming at it, you see people at their absolute worst. That's the worst that you're ever going to see them. They're at their most bitter, and they're just not thinking straight most of the time. So you just kind of have to keep that in mind. But then as you keep that in mind, the children really suffer quite a bit more so than you would think they would. Looking out and thinking more about the children than they were about themselves. But so that's kind of how I got into it, how I got into shared parenting. As far as what it would mean for the court system, as I perceive it, we are essentially overwhelmed at this point. When I say we, the court system, I mean the court system's overwhelmed with everything that's happened with COVID right now. We're just having a terrible time figuring out how we're going to catch all of these cases up. And the priority, like it or not, is going to be criminal cases for a while, getting jury trials started back up and so forth. Most judges have a criminal background. That's kind of how they get picked. They'll oftentimes have more experience with criminals. So that's kind of what they're interested in most. And it is very, very important. I would expect that we're going to have most of our judicial resources devoted towards catching the criminal side up, because it is very important, and it's going to be, what catches the interest of the judges, most of the judges. And I'm already starting to see some fairly alarming things happen. And I believe I shared this with you a while back. One of the local circuits here has passed a standing order that essentially says that custody issues will be decided based upon whoever had the child 7 days before something gets filed, an action gets filed. And that all happens without a hearing of any kind. In my opinion, that does not satisfy due process, and that's likely to get tossed out if someone challenges it at the appellate court level. But that I think the point is that judges are trying to find creative ways at this point to lighten the load that the family court system has on their time, because they have to do the criminal and they have to do the family as well. To me, shared parenting is the perfect solution to that problem. We know what it does. We have seen how it operates in Kentucky. We don't have to go into this blindly. We know exactly what happened in Kentucky whenever they implemented this. They, within a couple of years, I think, saw an 11% reduction in their family court cases, their custody cases. And what was surprising at that was the reduction that happened with the family violence complaints that happened as well, because and I believe that this is the case for Kentucky. In most of these shared parenting bills that get proposed, there are always going to be exceptions to to the presumption in favor of shared parenting in cases where family violence has been an issue. So if you're thinking about this logically, you're kind of thinking, well, if shared parenting is made the law anywhere, then you're going to see an uptick in false allegations of domestic violence. And so that's kind of what I expected to see in Kentucky. But the surprising thing is that it did not happen there. And in fact, those cases dropped by about the same percentage, if I'm not mistaken, about 11%. I think we're still trying to figure out why that is. My theory is that, we don't realize how much conflict and how much very bad conflict that can lead to family violence occurs because of the way people are treated by our family court system. I think people realize that they may not understand the statutes and the case law and so forth, but they see one situation getting treated in a certain way by one judge, and then one county over getting completely different treatment. They know that's wrong. They know that that is, inappropriate government action. They, inherently, about equal protection, and that's not equal protection. That is the opposite of equal protection. That is the whims of one judge carrying the day in one county, and the whims of another judge, going in a completely different direction in another county. And that's the problem with our system. There's too much variability. It's unpredictable. The attorneys love it because that means you gotta go into every single case, and you gotta do the discovery, and you gotta have a hearing and so forth. You gotta figure out who's your judge, what kind of mood is that judge going to be in that day. And you can't give your clients any answers until you figure all that stuff out. So it costs a lot of money. And, we family trial attorneys make a lot of money off of it. It's not really our fault. I don't think. It's just we have all collectively, and I'll take some responsibility for this. The judges and the attorneys have collectively allowed a system, to kind of coalesce that just doesn't make a whole lot of sense. So, to be fair, the social scientists have kind of, said, hey, we share some of the responsibility for this. We didn't give good data, at around the time that divorce was proliferating and becoming much more common. We didn't give good data that would say that you can't just split these children up from their parents and expect everything to be fine. So they've kind of fallen on the sword and said, that's our fault. That's our bad. We didn't give good data to the policymakers and impress upon them how badly this could go if they chose to do these, these primary physical custody type arrangements. And then I think the attorneys and the judges also share some of that responsibility as well. We let ourselves get out of hand in terms of giving too much discretion to trial judges and letting them just basically say, well, they're just going to make the decision and that's going to be it, because we got to have finality in these cases. And that's the only way we can figure out how to do it. Discretion is necessary in some situations, but when there's too much just unbridled discretion, you can't have that and have equal protection at the same time. That's a big, big problem.
Right.
Let me let you say something, Charles. I've been talking so much.
And that's something that I don't think that you touched on, something that I don't think that everybody realizes. We talk a lot about family courts, but family courts, at least in Georgia, and I can't speak for the rest of the country, they're, with the exception of Fulton County, which does have a family court section of the Superior Court, most judges will hear family court cases on Tuesdays and then criminal on Wednesdays. And then, I can tell you that the judge that heard my custody case is hearing the something to do with the elections and counting ballots.
Right.
So the judges hear a plethora of things. They're not necessarily experts in family law.
That's right. And I mentioned that a little bit earlier. This is, I'm just going to say this is what it is. When judgeships open up, when you have an early retirement or you have a judge pass away, most often those judgeships are going to be filled by governor appointment. And a lot of times those appointments will be filled by district attorneys. And the reason for that is that the governor essentially gets to make two appointments at the same time. And, it doesn't matter whether it's a Democrat governor or a Republican governor, they all like to be able to appoint two positions at once. So that being the case, more often than not, you might see a governor just appoint, the district attorney or appoint someone with a criminal background into those positions. And those folks, not always, but a lot of the times will be, they'll start their careers in the district attorney's office and they'll move up the chain. They'll eventually, hopefully get elected district attorney. And a lot of them have absolutely zero experience in the civil arena, in any sort of civil arena, but particularly in the family court custody type arena. where I think it surprises some people as to how complicated it is. It can be extremely complicated, and it's just not at all uncommon for judges to not understand how child support works, for example, and let alone how custody works, and all of the ways that the Constitution does come into play with those cases. But I think that it's a very common mistake for judges to look at the statute and then never make a constitutional analysis on how that plays into the case as well.
Right, right. So what is it that you see now? Judges right now, they could unilaterally come up with a 50-50 kind of there as a default, based on the science that does show that that is in the children's best interest. Obviously, it's rebuttable, and I think that people get a little bit confused. We'll get to that in a second. But they could do that. But do you see them doing that? Is it common for them to do that? What is most common? What are they looking for? Have you seen gender bias or racial bias or whatever other kind of bias you can?
Right. Well, my experience has been, and you're learning things all the time. I think you and I have discussed that there's a case, Baldwin versus Baldwin. And that case was, I want to say it was in the 1990s. It was a very interesting case. But eventually the upshot of that is that there's one of these little nuanced rules that, not everybody knows about. But when a party asks for shared physical custody or shared parenting, joint physical custody, the court is then, if the court finds both parents to be fit parents, which is going to be the case more often than not, much more often than not, the court then must give due consideration to that request. The court is not required to give due consideration to any other type of custody except for shared parenting. And that is, the case that you and I have discussed many times, the Tyler Perry case. That's what that is all about. In that case, Chief Judge Pryor, veteran of the bench, been practicing or judging for years and years and years, decades probably. I don't believe was at all aware of that requirement. And again, that's not uncommon to have a judge just be completely surprised by that. But because the record did not make it clear that he had given due consideration to Mr. Perry's request for shared parenting, he was reversed and basically instructed to reconsider the case and to give it due consideration this time. And we don't feel like he did. So we're in the middle of appealing that case again, but we'll see how that one comes out. As far as what I've just kind of personally observed in my practice, yes, there is quite a bit of gender bias that still exists. Every once in a while, you will, like the case in Tyler Perry, you'll get a judge that will pretty much come out on the record and say it. In Judge Pryor's case, he said, I think I'm quoting loosely, but essentially what he said was, I just believe a child that's been with the mother should stay with the mother. And there's, I think the other attorney and I have argued quite a bit as to whether or not that really indicates gender bias. But I think if you look at the facts of that case, it's pretty clear that that's exactly what it was. That is a sincere belief. I don't question Judge Pryor's belief on that. That's a sincere belief on his part. The trouble is that's the sort of belief that judges ask juries. Can you set that aside and do your job as a juror and put aside your prejudices and so forth and render a judgment according to the law? Well, judges have to do that too. And sometimes they're the ones that are reading those instructions to the juries, but when it comes down to it, they don't always succeed in putting those prejudices aside and rendering a judgment that is free of bias the way that they're supposed to. So yes, I've seen a lot of gender bias. There just seems to be still a tendency to want to award custody to mothers, to just feel like that's the safer option for whatever reason. And I think that there's an erroneous belief that that's the way that it's always been. And, we're just sometimes progress just moves too quickly, and they're unsure about whether we're moving in the right direction or not. The ironic thing about that is that that's not the way that it's always been. And you may be familiar with this, Charles. Before that doctrine was put into place, which is the tender years doctrine, this belief that children are just better off with their mothers for the first 6-7 years of life at least. Before that was in place, there was, I guess, what I call kind of the property rights doctrine, this belief that that children were the property of their fathers, and as were their wives. And if there was going to be a divorce, which was unheard of back in those days, the wife is not going to be allowed to take the children, the father's property, with her. So that was always the default, is that the fathers always get the children, in the unlikely event of divorce. I think that the tender years doctrine came about in the time that women were, asserting, kind of their place in society, and right. Asserting their equality of men, which of course I agree with. It was the tender years doctrine, I think, was a knee-jerk reaction to very bad policy that was in place, that, the men should always get the children. Well, then we go from that to the women should always get the children. And then we go from that to, well, whoever's the better option should get the children. Where we need to end up with this is we need to recognize that both mothers and fathers play an important role, a critical role in the development of children, and they both have to be respected. Their time with the children both has to be respected. There is no safe way to do this, by just marginalizing one or the other. This is, it's not as difficult as I think some people perceive it's going to be, but even if it were, we have to do it. Our children's well-being depends on it.
Right. And I guess maybe I've tried to explain rebuttable presumption a lot of times. People don't really necessarily understand it. They think that it's concrete or in some kind of way. Now, we know that that's not the case. There's a rebuttable presumption that you are innocent until proven guilty. Yet, if you go down to any jailhouse, you'll find that that presumption has been overcome many, many times.
Right.
And what we have asked for is a rebuttable presumption by clear and convincing evidence.
Right.
That a parent is not fit, willing, or able. So could you kind of explain that maybe in a different way other than I have,
right.
Or maybe in the same way? I don't know.
Well, I think, to me, again, it's going to be the vast majority of cases are going to involve parents who are both fit. Maybe one was a little bit more, as hard as I've tried to fight it in my own situation, there is a little bit of a division of labor that happens between me and my wife, taking care of our child. She's downstairs right now taking care of her while I do this. So, it's not exactly equal on every single thing, but I try to make it as equal as I can. But in every case that comes up, what we end up fighting about in court is, Mr. Ware, how many times did you take your child to the doctor? Well, I went 95% of the time. Well, your wife went 100% of the time, so she gets custody. That's literally what we end up doing. And court is fighting about kind of things like that, and fighting about who was more the caretaker of the child, and who was more of the the person who I guess earned the living or whatever. And I think that the point is that, hey, we're getting divorced. We are separating this family for better or worse. That's the decision that you guys have made. Everybody's going to be a caretaker moving forward, or both parties are. Both parties are going to be a breadwinner moving forward. You're not going to be able to do the division of labor anymore because you're not together anymore. Everybody's going to be expected to do what's necessary to take care of this child moving forward. And that's the government's role, in my opinion, is to basically say that, hey, this is what you guys have decided, and it's not up to me, the judge. It's not up to the court to micromanage how that's going to go about. That's your job. That is the job of the parents to figure out all of this. What the court needs to do is to divide up parenting time, which more often than not is going to be 50-50, for fit parents, and come up with a scheme for how major decisions are going to be made. Beyond that, the court needs to butt out of it and stay out of it and say, even when invited to get into those issues, say, no, that is your job, parents, that you guys have got to figure this out, just like parents who are still together do. There's no difference here, really, except for those two issues. So as far as the presumption goes, it's important that people understand that that is the rule that is going to exist for most situations. Now, there are going to be situations where, as you said, certain parents are not able or willing to have that role of a roughly equal responsibility and equal parenting time. One example is going to be when a parent, has a drug problem that just doesn't allow for it, has, some sort of physical disability that won't allow for it. When they have some sort of a mental disability, and I'll kind of throw in, family violence into that, because I just don't think that that's normal for people to be violent with each other the way they are. I think there's definitely mental issues going on there whenever that happens. So I would categorize all of those things as being unable to exercise shared parenting. There are also people who are just not interested in it. And they may not say that. Of course, they're not going to say that when they're in court, but they demonstrate that in ways of, just consistently not meeting a bare minimum of what you would expect. That, I guess that is, that's tough to quantify from the very beginning, exactly what that's going to look like. It's usually, in my experience, I've got a case right now where the dad's just been given opportunity after opportunity. Couldn't have asked for a better guardian ad litem in terms of shared parenting, but he just won't do the work. He needs to get counseling with his daughter in order to repair the relationship there, and he just won't make time for it. That would be an example to me of someone who's just unwilling to do it. It may be because of work. It may be because of whatever other things they're more interested in. Some parents just make it very, very clear that they're not really. They're not really in the game. If you have parents who live on opposite coasts, it's not going to work there, but you should still make every effort to equalize parenting time as much as you can during school breaks and holidays and so forth. But again, I think the court is always given room to identify those kinds of situations, even with the presumption, and say, this is why it's not going to work in this case. We have family violence in this case. We have I just can't figure out a way to make it work in this case. And that's what you would do as a judge. You would explain that in your ruling as to why it just doesn't work and why you feel that the evidence has rebutted the presumption by clear and convincing evidence. But I think the clear and convincing is for those who aren't in the legal field, it is the highest burden of proof that you have, short of beyond a reasonable doubt in the criminal context. In the civil context, it is the highest burden of proof that there is by clear and convincing evidence. So this is basically saying to the judge, you need to do this in almost all cases. You've got a particular case that this just will not work for. You've got to have the highest level of evidence that there can possibly be in a civil case in order to justify that ruling. That's what the appellate courts are going to expect from you. And they're going to look at that very closely to make sure that, that's actually there whenever those cases come in front of the appellate court. That's my vision of the way that this would work if we're able to pass the legislation.
Okay. And now you had testified on House Bill 1140 last year
Right.
at a committee hearing. You said something that was interesting, and I don't think that a lot of people really realize it. Right now, you and I had talked a little bit before we came on here, and you said that you're doing most of your work is now in the child support arena,
Right.
for child support. So you're very well versed in that. Can you kind of go over what that would mean for what shared parenting means for child support collection?
Sure. And before I say anything, let me preface this by saying that my opinions about child support are my own. They don't, although I'm a subcontractor of the Department of Law, I certainly do not speak for them. I don't speak for the Division of Child Support Services in any of my opinions. But I will share that we do annual seminars each year. All of the special assistant attorney generals and the assistant district attorneys who do this child support work on behalf of the state, we have a seminar each year. I think we're going to miss it this year because of COVID, but it's our one chance to kind of get together and share ideas and so forth, and basically do our continuing legal education requirements. And for the last several years, we've kind of been told that the federal government, which provides probably the vast majority of the funding that that makes the Division of Child Support Services go, and a good portion of that is from the federal government. If we didn't have that federal funding, we just wouldn't be able to operate. The division would not be able to operate. But the federal government, will make changes to the way that we enforce child support and establish child support. And whenever they do that, it's usually they basically say, okay, you need to make these changes. You need to implement these changes in the way that you're going about your mission. And you don't really have a choice because your funding is going to be conditioned on you making these changes. A good example of that recently is up until very recently, we did not have any kind of mechanism by which an obligor, a person who's paying child support, who is incarcerated, could get that child support lowered or eliminated while they were serving out their period of incarceration. And the case law in Georgia was essentially, look, you committed a voluntary act that landed you there. Why should you get any relief from your child support? That kind of was the way that we approached it in Georgia, until the federal government said, we don't think that's right. We don't think that people should have to continue paying child support while they're incarcerated. And, people can have different opinions on that. But the long and short of it is when the federal government said your funding is going to be conditioned on that moving forward, Georgia changed its philosophy and changed its law. And, and now we do have a mechanism by which incarcerated parents can seek a modification. And usually the child support gets eliminated while they're incarcerated. And then once they get out, we modify it again based on their circumstances there. That is the reality for how these kinds of things work. What I've been hearing for years at these seminars is that the federal government has been studying the issue of how parenting time affects compliance rates for child support very carefully. And when I say studying, is years, if not over a decade of very careful research into this. And what they have found is that parents who are given additional parenting time and have a relationship with their children are vastly better payors than parents who are essentially told to, give us your money, but don't bother trying to see your children. You need to go get an attorney to see about all of that. So the upshot of this is that we are being prepared for the day when child support people like myself will have to kind of get involved in custody issues. Right now, there's a statute that forbids us from getting involved in it. If the federal government decides that they want us involved in it and they want us to establish at least a minimum amount of visitation for these payors, because that's going to increase the chance that they're going to be good payors, then that's what's going to happen. That statute will be rewritten or just gotten rid of entirely. Again, that's the way that these things work. So I guess what I was trying to say at the hearing on 1140 was I kind of envision that is going to have great impact on the way that custody is handled in Georgia, because if you think about it, the number of just straight up child support cases that exist in our civil court system right now is very, very few. And it's usually going to be very wealthy people who are fighting over large amounts of child support. The vast majority of people use the Division of Child Support Services to help them almost mediate those kinds of issues. Now, if we all of a sudden go into the business of custody, then those custody issues that so many trial attorneys are making money on right now, all of a sudden, those people might just kind of decide that, well, I'll just let the Division of child support services handle my custody issues as well. That is going to have a dramatic change, a dramatic impact, and it's going to be a great change for trial attorneys who are accustomed to kind of having a monopoly on custody. I don't think that's going to exist anymore once that happens. And this is not a question of if, this is a question of when this happens. But from a standpoint of enforcing child support, there's another angle here that when there is more parenting time, the child support amounts do tend to be a little bit lower. There's a little bit of allowance for a parenting time deviation. Lower child support is, surprisingly enough, easier to enforce because people are more likely to pay, more reasonable amounts. That's something that has already kind of found its way into enforcement for child support. It's the concept of the right size order. You don't want an order that's so ridiculously large that people are never going to be able to pay for it. They'll just disappear. They'll go to Mexico, or they'll just stop working entirely and live with a family member, and you can't do anything to them. You can put them in jail every once in a while, but then once it's shown that they really do not have the means to pay, you have to let them out. You can't just keep people in jail whenever they don't have the means to pay the child support that they're supposed to. So they basically get demoralized, and they feel like, well, this system's just rigged, and I'm just going to remove myself from it or whatever. Whenever it's that bad, we don't want, we don't want things to be that way. We want these to be reasonable amounts that people can actually do. I think that ultimately the vision is going to be, we want payors to be involved with their children. We want them to have child support amounts that are manageable and that are appropriate. And if you do all these things, you're going to find that a lot of these people that you thought were deadbeats really aren't deadbeats, and they are capable of a whole lot more than we give them credit for. And then you're going to find that there are very, very few true deadbeats out there that just don't care anything about their children. But the system, it's got to be more fair. And I think we're making good progress on it. We still got a long ways to go, but those are some of the things that I think are coming. In my mind, it's going to be a whole lot easier for us, the child support attorneys that are involved right now, if we have in place a system that has kind of gotten judges and attorneys used to, we're going to have more involvement with the payors. Of course, there's going to be less for us to do. So really, to the extent that attorneys want to, kind of keep control of this a little bit, keep this privatized versus so much of this going towards the government and becoming the responsibility of the government entities, you had better do this. You better support this, because if you don't, that's what's coming. That's my firm belief on what we can expect in the future.
Okay. And I guess my last question, and then you can add in anything else that any other ideas that you have.
Right.
Some of the pushback has been, and it doesn't make any sense to me, but maybe you have some, is that this will create a new level of conflict. All of a sudden there will be more conflict in divorce cases and legitimation cases, and they're kind of treated the same way, divorce and legitimation in many ways. Obviously, there's maybe some more facets, dividing a house or something in a divorce.
Right.
Although I have found that dividing a house is generally not something that people spend a lot of time on. I mean, if you've got a $300,000 house that you owe $250,000, both sides shouldn't spend $50,000 on attorney's fees.
Right.
But what do you see that as any way that this would increase conflict, and then any other thoughts that you might have?
I don't. And the only thing that I have to go on there is, again, what's happened in Kentucky. we have fewer cases. It seems like more people are either deciding to stay married, which I think is people who are for the concept of marriage and want to defend marriage. Right now, for some folks, it is way too easy to cast the vote to break up a marriage. If you, again, there's this element of unpredictability in the state of Georgia that people might think they know what's going to happen, and then they go into court, and maybe you get that judge that believes very strongly in shared parenting, and they are out there, and basically resists and says, ma'am, I have to give due consideration to shared parenting because he's asking for it. I don't have to give due consideration to anything else. And you're both fit. I find you both to be fit. Why would I do anything else in this? Why would I do what you're asking me to do, which is to give you full control over the child? Why would I do that? You've got some judges out there that are that way right now, and you're going to see more and more of them, even if this legislation does not get passed. I think once those expectations change, there will be more willingness to either stay married or to have an amicable divorce. Let's work this out. I would say to anyone, do not underestimate the amount of bitterness that gets developed during the process itself, during the process of divorce. A lot of times people go into this with the best intentions to be fair to each other, and then it just spirals out of control from there. I think a lot of conflict is going to be solved that way. I think a lot of conflict that is caused by people who believe, rightly so in a lot of cases, that they've been treated unfairly by the system. Once they believe that, things look pretty equal now, this looks a whole lot more balanced, I think that a lot of that conflict is going to go away. And you're talking about some of the most desperate conflict right there, where you're, the government has essentially come in and turned your life upside down, taken your children from you, and really doesn't have a good reason for doing so. And you got attorneys like me who are out here saying, I don't think it's constitutional, what's been done in that case. Those people have a legitimate gripe, and hopefully they don't turn to violence, but you can kind of understand how they get down that path. But at any rate, we need to look at Kentucky. We need to look at other states who have done something like this and see what's actually happening there. Kentuckians are not so different from Georgians that they just have, a completely different way of reacting to the same sort of legislation. What have they actually done? What have the people there done? Have they increased their level of conflict? And if not, then those who suggest that the conflict level would increase, what's your basis for that? Where's your evidence of that? Is it just, something that you think is commonsensical? Well, it's not commonsensical if it's not actually happening in places where this has been done. So they've got to come up with something better than that to be convincing.
Right. And I know I said that this was the last question, but I'm going to show this question here. Jennifer just sent. Jennifer is actually an attorney up in Michigan. What struggles have you had in pitching this to the judge, and how to argue it for a resistant judge?
I would be the last attorney to ask on how do you convince judges, to accept this. That's what I'm here trying to do right now. So if I've given you the impression that I have had, just success after success in court arguing this, that's not been the case at all. I consider it to be a success whenever I go through, what I've talked about here tonight, and the other side really doesn't have a good argument. Sometimes that other side is going to be a judge, and just really is just kind of overwhelmed by our side and doesn't really have much of a response. I can't help the fact that they're the ones wearing the black robes and I'm not. They do have the power for right now, but the true power lies with the people. So many people have been through this system, and I can understand that they really, I have clients right now where I say, you need to get involved. I know this guy, Charles, you need to talk to him. It may be too late for your case, but for the next person who's in your position, maybe there's some good that can come from this if you get involved. And and of course they want to say the right thing and say, oh yeah, but I think really when it comes down to it, so many people, I mean, this is such a traumatizing experience for so many people. They just want to put it behind them, and they are likely to just kind of disappear. And then so many of the rest of us, we don't know what's really going on in these family courts. We're just ignorant. So there's a very small set of people who kind of know what's going on, and then still have the wherewithal and the courage and just something left in the tank to fight the way that you are, Charles. We just need to find those folks, and we need to just keep putting our message out there, whether whoever's in front of you, whether it's the whole world, the internet, whether it's one judge, whether it's a colleague of yours. I think I've talked several of my good friends who are attorneys into being believers. My good friend Mike Childs is my business partner. He has his own firm, and we share a building. I dragged him up to Boston for the Shared Parenting Conference. It was either 2016 or 2017, and made him go with me. And before that, he was a skeptic, and after that, he was like true believer from then on, and preaches it about almost as passionately as I do. So my friend Jenny Morris from law schools, she's my co-counsel in the Tyler Perry case, obviously believes in it very strongly as well. There are more of us. Once upon a time, I thought I was the only person in Georgia who supported shared parenting, but I've met you. I've convinced some people. I've met others. There's a lot of us, and we're growing. And I believe that one day, this is going to be the law, and we'll look back and wonder how in the world, were things so backwards once upon a time. So I hope that day is coming soon.
Absolutely. Absolutely. Well, I told you that I'd keep you for 20 minutes, and right now I'm going on 58 or 48 minutes. So
no problem. Happy to do it.
I really appreciate you joining us today. And I appreciate your support that you've always had for us. It's always been unwavering, and we really appreciate that as well. And hopefully we can get these laws changed for the betterment of our children.
All right. Well, let me take the opportunity to thank you, Charles, for everything that you've done. We all, I think, go through periods of being a little bit discouraged and feeling like we're the only one out there that's fighting for something. And I kind of had gotten discouraged before I met you. So when I met you, that gave me the will to carry the fight on a little bit longer. So I'm glad to know that you're out there, and thank you for everything that you're doing.
All right. I appreciate it. All right, everybody. Thanks for joining us. We're probably going to have more content. We appreciate Mr. Ware coming on, and we will talk to you guys later.
Thank you.
Thank you. All right. I appreciate it. I really do. I think
it went well, or from my perspective, it did.